Aboriginal and Torres Strait Islander viewers are advised that the following program may contain images and voices of people who have died.
So full stand on the summary jurisdiction is now in session.
Sherry Madigan, event correct.
After making other stops, the defendant headed back towards Pelly community.
ABC cameras have been granted unprecedented access to courtrooms in Darwin and in the bush for an intimate insight into the Northern Territory's justice system.
I want people to understand that they're entitled to have access to justice and to understand what goes on in court.
So make sure you come to court with the
Over 3 weeks, we recorded hundreds of cases.
I think it's really, really important that we stay in touch with what's happening elsewhere. It's important to remain shocked.
Ms Hancock, the criminal history is literally littered with offences that relate to alcohol misuse. Is the defendant going to do anything serious about his alcohol misuse?
We captured a system overwhelmed by alcohol-related crime and community dysfunction.
The vast majority of violence that we see is alcohol-fuelled. There is a clear association between the availability of alcohol and the commission of offences of violence.
It's a justice system that's also crying out for alternatives to sending people to the Territory's overflowing jails.
A justice system that simply treats everyone as being the same, as needing the same outcome, I think is a very ineffective justice system.
If you could call Jairus Galloway.
We meet defence lawyers run off their feet by Indigenous clients struggling to navigate the legal system.
The sort of situations that come up for our clients are often unique. The challenges of understanding their backgrounds, the cross-cultural communication issues that often arise, the cultural and social issues that come up make it vital to have an Aboriginal legal service that provides a truly culturally relevant service.
Will you be able to assist some of the people this morning? Okay, all right, we'll see how we go. If we've got languages that we can't, we'll start with what we can start with.
And we meet the translators for an insight into the lives of clients who are trying to balance their cultural obligations with legal obligations.
Professional, trained interpreters are the only way of alleviating the huge communication barrier that exists in the Northern Territory.
Bush courts have been a feature of the Northern Territory's justice system for decades. Beyond the main centres, court convenes regularly at more than 30 remote communities. At Aliangula on Groote Island in the Gulf of Carpentaria and at Goombulanya in Western Arnhem Land, court comes to town once a month. Magistrates and their staff, prosecutors and defence counsel often travel together for 2 to 3 day sessions which handle up to 100 cases. In these far-flung courthouses, magistrates encounter the whole gamut of crime and endeavour to dispense justice in a manner which the community can both see and understand.
There's not a separate place for the magistrate to go and wait, and if there's any reading to do, there's no place for the lawyers to take instructions. In fact, you would have seen they were actually taking instructions either outside where there's no sort of confidentiality or at this little space at the back of the courtroom, which isn't ideal.
The victims who come along to give their evidence have to sit in very close quarters to the person who is alleged to have offended against them. There's difficulties around the lawyers having the privacy to take instructions from their clients because there's often no interview rooms, anything of that nature. So people sit outside and have to interview their clients in that sort of space.
I think it sends a very bad message to Aboriginal people when they've got to see their lawyers under a tree or out on the veranda. There needs to be an interview facility where people can be seen with confidentiality and, as I say, with some dignity. We need to make sure that victims aren't in the line of sight of people who are accused of crimes. That happens all the time because there aren't facilities to properly manage that. It doesn't say that they get equal justice, which they are entitled to.
Prosecutors face the same sort of difficulty of trying to proof their witnesses with no special facilities around that. So, as a magistrate sitting in that sort of setting, I think we have to be very patient and try to accommodate as best we can everybody's needs.
Having a community court, having a court operating in their community is at least a start. It shows that the court is serious about engaging with Aboriginal people and doing to some extent things on their terms, but at the same time the court system remains completely foreign to a lot of people in those communities.
Of the Northern Territory's total population of 212,000, more than a quarter is Aboriginal. The Territory has by far the highest imprisonment rate in Australia, 5 times the national average, and more than 80% of those prisoners are Aboriginal. The Territory also has the highest recidivism rate in the country. Almost 50% of those released from jail are back inside within 2 years. Cultural factors are at play even before Aboriginal offenders get to court.
There is, very sadly, a very high mortality rate in Aboriginal communities, and when people die there are particular things that have to happen, sorry business. People will want to attend to that rather than coming to court.
Part of the work we do is to try to make sure that our clients understand what's going on in court, they understand the reasons for being there and the outcomes, and we also work hard to make sure the court understands the cultural realities and the sometimes very complicated social realities of our clients.
We've got, a huge logistical exercise, as you see. It's very, very important that people obey. After all, they've been given bail, and bail is an undertaking. That is a promise that says, I will come to court on that day.
All right, there are various non-appearances. It's now 11:15, so if these people haven't arrived, we'll have to make a decision. I can't wait for them.
There might be significant cultural events like funerals, or if people are going through ceremony, and there are often basic things like rivers being up and people's cars breaking down and all of those sorts of things that can make it quite difficult.
Generally, if there is going to be a big funeral on in town, people will say so, but I think if you make it clear that that doesn't mean there's going to be a blanket just allowing anybody, because then some people who actually maybe are not going to the funeral can then tag along.
Well, I've got 3 files for Mr. Nalorman.
You do have people who never come to court, and their records are littered with warrants for their arrest.
It's a warrant file, Your Honour.
It can be for those people a convenient excuse. It's important to have some degree of flexibility.
Your Honour, Mr. Nalorman instructs that he went to Beswick for his uncle's funeral. He missed court on the last occasion, Your Honour, because he was trying to get a lift.
By the same token, I think it's also important for people to understand that if they are summoned or bailed, they have to come to court.
Mr. Derilla came into the office this morning, Your Honour. He informed me that he was on his way to Unbecomber for the funeral. Application is to adjourn.
I'll give him a chance once again to appear tomorrow, but in the absence of his appearance tomorrow, again, the likely course of action would be that a warrant will issue. Some people will just not turn up, and then that creates a problem of having to issue warrants for their arrest, and then they're back into that cycle in the arrest system again.
We can't navigate those competing obligations for a client. We can only try to assist clients and the court to bridge those two cultures and to try to make sense of each other.
More than 100 Aboriginal languages survive in the Northern Territory. English ranks 2nd, 3rd or 4th for many of those who come before bush courts. The Aboriginal Translator Service provides interpreters in 20 of the most commonly spoken Aboriginal languages. Those translators deliver around 1,000 hours of interpreting every year in more than 20 bush courts. Without them, injustice would prevail.
It's one of the big successes of our court that we take justice to so many places and do it remotely, and that we do it increasingly hand in hand with the interpreter service in languages that people can understand.
You actually need a highly trained, specialised court interpreter who understands the court system, who understands court jargon, who is comfortable and confident to actually interrupt a magistrate or a lawyer when something is being said that either can't be interpreted easily or that isn't understood properly.
Randall Norman, you stand charged that on the 29th of March 2013 at Appellants in the Northern Territory of Australia.
We have up to 5 language groups in some of the places we go to, and we, through the interpreter service, are able to make sure that proceedings are conducted in a way that people understand.
One of the things that's probably not appreciated or understood is just how different Aboriginal languages are from English.
On that same road.
They have completely different grammatical structures, completely different grammatical systems. There are certain things that we do in English that really aren't easily replicated in Aboriginal languages, in the same way that there's lots of things that Aboriginal languages can do that we can't do in English.
Sometimes the court itself would say things that were based on our own level of misunderstanding. For example, just interpret exactly each and every word that's said. Now, you know, language isn't like that. It's all about meaning.
Sorry, Aaron, on the same day and date in Goombanya, Northern Territory, did drive or cause or permit a vehicle to drive on a road or part of a road whilst that road was part of the road was closed, in pursuant to Section 11 of the Control of Roads Act, contrary to Section 11.5 of the Control of Roads Act.
That one was a bit of a mouthful. I think he drove on a road that was closed.
It's difficult to overcome language issues across the board, and it is really important and incumbent on us as the system to use language that people can understand. I think one of the real difficulties is that in the Northern Territory, the law says that we are required to have the charge read to the defendant in the exact language of the charge, which is, it is simply not understandable by anyone.
Defendant and co-offender walked from abandoned camp area towards Demed and entered the enclosed compound by climbing through a hole in the fence. Defendant approached the rear office.
Sorry, just a moment. Does the defendant need this to be read, because we're going awfully fast and there's no interpreting going on?
And then there becomes a process of breaking that down into plain English, not simple English, plain English, and then having that interpreted into another language. So that's really where it becomes important for all of us to use plain English. And then, in terms of Aboriginal people or other people who don't speak English, making sure that interpreters are there and that they do actually understand what they're being charged with or facing.
One of the really crucial things is for the interpreter to actually be briefed. When a court matter is heard, generally everyone knows the story except for the interpreter. The client knows what's happening, they were generally there. The lawyer knows what's happening, the police or the prosecutor knows what's happening, and even the magistrate will have the charge sheets and a few other things like that. And so if you just drag an interpreter in cold, they've got no context, no ability at all to know, is this person pleading guilty, is it an adjournment, is it a hearing, what's going on, unless they've been properly briefed.
Right, Mr. Lilara, you have bail.
I try to make sure that I actually speak directly to people to try to explain to them what's happened rather than just talking to their lawyer and expecting that they understand what I've just said to their lawyers.
If police come to check that you're at the house, then you have to come to the front door and show them that you were there.
I do make an effort to try to have people understand exactly what's going on.
Unless there is some medical emergency.
We're conscious of the pressure it puts on people. They've got to navigate difficult cultural and family issues within their community. They've often got to deal with the sort of grisly business that comes before the court, and they take a lot of that on.
It was felt really important that they be seen as professional and independent, and that the court could have some level of expectation as to the level of expertise, and that there were appropriate standards and that there was proper training being given.
It really does take a few years to develop a good court interpreter. It's not something you can do overnight. So we do have quite an extensive program in place where new interpreters get mentored and trained by older, more experienced interpreters and build up their skills and confidence. We generally wouldn't send an interpreter into court without legal training. It is possible for something to go wrong, and that's why it's a great step that the courts and legal services are now working to actually provide the support needed to make sure that accurate interpreting happens consistently.
And Sergeant, if you could use as plain language as possible, that would be really helpful.
Certainly. Cameron Navigator of Owen community unlawfully entered a building, namely the Gumbalanya Meatworks, with the intent to commit a crime, namely stealing. Contrary to section 213 of the Criminal Code, had he plead guilty or not guilty?
It means he went in there to the meatworks and he was going to steal things from there.
It's absolutely staggering. There are a number of people who really cannot communicate in English.
Your Honour, the facts are that at about 4 a.m...
Even through translators, defendants and victims still struggle to understand the complex language of the law.
On 20th March 2009, in an electronic record of interview,
acknowledging the low education standards of most of those who come before the bush courts, all parties try to keep their language simple.
I think what's really surprising, shocking really, is that sometimes these are people who the court is being told have completed year 10 at school, or year 11, or even year 12.
He tells me that he hasn't had any work since leaving school. His literacy is clearly very poor, and he doesn't speak English, and in fact he's very hard to communicate with, even with an interpreter.
All right, if you stand up please, Mr. Navigator.
You're told that they're not literate. You can often see from people's handwriting on their bail undertakings that it is very immature handwriting. So the whole gamut of literacy is shockingly poor for many people in the criminal justice system.
What concerns me is what are the prospects for those young people if they have insufficient English to be able to participate in court? How do they enter the workforce? How do they even get the training to enter the workforce? I think it's a pretty dismal situation that there are a lot of young people out there whose families have not insisted on them going to school, who are now left in a situation where their prospects are extremely poor.
The workload that our lawyers carry is massive, frankly, and it places a great strain on our service. But we're still very proud of what we're able to achieve, and we still think that we're able to provide a really great level of service within those limitations to Aboriginal people. Your Honour, we understand that Tyrus was here from earlier in the day. He's unfortunately not stayed around. If he might be called, in the event that he's not here, I'll be asking the court to put that matter over till tomorrow to give us a chance to try to locate him. As I say, he did present himself earlier.
Regarding file finishing 169, I asked for an adjournment for representations on that file. There are about 7 charges. I've spoken to my friend briefly, but we think we'll need more time to consider those representations.
I think we really struggle to have enough time. I mean, I think our lawyers are very good at knowing when they need more time, and they can adjourn matters and they can make sure that they come back next time. We do put matters off to make sure that we are properly investigating them, but there's always a much higher risk when the time pressures and the work pressures are that great that we'll miss something.
They've got to provide legal advice, and they've got to be there for defended hearings, and often they're the ones who've also got to be chasing up all sorts of inquiries and assisting their clients in ways that go above and beyond a legal service. I think they do an amazing job. They seem to be required to have to assist in an enormous range of ways that, as I say, would go beyond what legal services do in city settings.
There are a lot of people to take instructions from. There's a sense of urgency about getting matters resolved, and it's very difficult for them.
Ms Hancock, are you ready with anything?
I'm not, I believe, Your Honour.
We do increase the number of days we sit if lists start to get too big. We're cognisant of that. We don't say, well, no, this is a fixed 2-day community. I mean, last year we seemed to have a lot of matters in Maningrida, for example, so I started sitting 3 days.
Mr Hunya, there was a defendant who Ms Musk appeared for on the last occasion, Mr Jogaba, and he was going to be undergoing an assessment for either Sunrise or Vendale, and he has been found suitable and there is a place for him tomorrow. The trouble is he's not here.
Your Honour, if I can just see if we've got contact details for Mr Jogaba.
Right. Is he someone you know, Sergeant?
Your Honour, if you like, I can go and track him down. It shouldn't take too long if there's some other matters you can go on with.
All right, because it would be a real pity for him.
We're very conscious to try and make sure that it doesn't actually affect the quality of justice.
If you could find him, that would be good.
Yes.
I'll make those inquiries. Just on the record, Your Honour, he did ring twice this morning at the police station. He knew the court was on. So.
The repeat nature of a lot of our clients offending, seeing the same thing day in, day out, and seeing people that we thought might have been on a good road coming back, that can be very demanding. We're not funded at a level that allows us to provide the level of service that we think our clients deserve. As I say, I think we do a great job with what we've got, but the fact is that our clients in remote communities aren't getting equal justice. The court doesn't have the time to give their matters the same consideration as it does in town. There are really massive pressures on.
It would be practically a nightmare to bring everybody into Darwin. The idea that the justice system is seen to be a part of the community and it's visible is very, very important for this issue of rule of law.
You stand charged on the 8th of March 2013 at Wollongong in the Northern Territory of Australia. You unlawfully assaulted Gwen Nailovich. That said unlawful assault involved the following circumstances of aggravation, namely that Gwen Nailovich suffered harm.
Perhaps, Mr Stutchery, these things, these are things that make this worse.
To that charge, you plead guilty or not guilty.
All right, thank you. Just sit down.
The idea that if people have done the wrong thing, that they are accountable to their own community and in their own community is very, very important. It's important from the point of view of the victims and also of the greater community.
Mr Gomadol says that he lost his cool, he picked up the rock, he assaulted her. As soon as he realised that he'd hurt her, he threw the rock away, felt very bad about what he did, and he left the scene before anything further happened.
It's supposed to be what we call a salutary experience, coming to court and have to face up to the reality, but if you've broken the law, that's your way of being accountable to the community, is to be able to admit it and admit it publicly, and that your acceptance of what you've done wrong and your penalty or your punishment happening in an open and transparent way. It's really important that people see that everybody's subject to the law.
Today I'm sentencing you for this incident where you hit your wife when you're in the middle of that heated argument.
We are saying to a person, you need to be punished for your offence, you need to be given the ability to rehabilitate yourself for the offence, we need to be denouncing your conduct, we need to be making the community safe.
It's also to send a message to other people, to say to other people, this is what happens when people commit these sorts of offences. It's also specifically to say to you, this is what happens when you commit these sort of offences. It also says, it's what is called denunciation. It is saying clearly that everyone says this kind of conduct is unacceptable and should not happen, and that we as a community say that. And it's also to promote your rehabilitation so that you can change and you won't do something like this again. And it's also to protect the community.
There are such a range of things that we're supposed to be achieving when we sentence someone, and even if maybe the court's the first time they've ever heard that in their life, then it is important that courts say it, because perhaps no one else will ever say it to them.
The Northern Territory's 2 jails, in Darwin and Alice Springs, are overflowing. A new jail, capable of holding 1,000 prisoners, is being built near Darwin at a cost of more than $500 million. Most of those who pass through the courts and into custody have acted out an alcohol-fuelled rite of passage. 60% of all assaults in the Northern Territory and 2/3 of all domestic violence incidents involve alcohol.
The main factor that drives the high rates of violent offending in the Territory, and certainly for our clients, is quite simply the grog. That's what's leading to their lack of impulse control and their often disproportionate, very violent behaviour. A lot of the clients, when we see them sober, are very meek and mild, but when they get very drunk, they become very violent, and it's something that we would love to see dealt with properly.
We've also got to bear in mind that the victims have also been the victims of traumatic pasts and often traumatic presents. And the children are going to be the future. They're often the observers and they're around too. So it's this balancing act, because, you know, it's also important. One of the roles that the court's doing is denouncing the conduct and saying this is unacceptable in a 21st century society.
Now, you've been to court quite a few times now for this. What this is all about is about that time when you went into Jabiru last year and you drank too much and you smashed the window of that hotel so that you could go inside and you slept there for the night. That's what it's all about. And today it's about getting your sentence, which is your punishment, and also the order to help you rehabilitate yourself for that offence. You've also been to court lots of times recently for things that are connected to alcohol and misusing alcohol.
I took this position up to try and be able to, as the oath says, to do right by all manner of people. And it's very sad that there are so few tools and that there's so little done to prevent that cycle starting in the first place.
And they've all been to do with alcohol. You have said that once you start drinking, you find it difficult to stop. And doing something about it is the best way, I think, of not only rehabilitating or fixing yourself up, but protecting the community. When you finish the rehab program, no drinking for the rest of that time. And after that, with what you've learnt in the rehab program and not drinking for a long period of time, you can then make your own decision about whether you think that you can drink at sensible levels that doesn't get you into trouble.
I think it's really, really important that we stay in touch with what's happening elsewhere. It's important to remain shocked and not accepting that some level of violence is okay.
Sometimes I despair as to how you can make a difference to people's lives so that they cease offending, so that they stop harming other people.
And community dysfunction.
The vast majority of violence that we see is alcohol-fuelled. There is a clear association between the availability of alcohol and the commission of offences of violence.
It's a justice system that's also crying out for alternatives to sending people to the Territory's overflowing jails.
A justice system that simply treats everyone as being the same, as needing the same outcome, I think is a very ineffective justice system.
If you could call Jairus Galloway.
We meet defence lawyers run off their feet by Indigenous.
Aboriginal and Torres Strait Islander viewers are advised that the following program may contain images and voices of people who have died.
So on a full stand, the summary jurisdiction is now in session.
Sherry Madigan, event correct.
After making other stops, the defendant headed back towards Appellants community.
ABC cameras have been granted unprecedented access to courtrooms clients struggling to navigate the legal system.
The sort of situations that come up for our clients are often unique. The challenges of understanding their backgrounds, the cross-cultural communication issues that often arise, the cultural and social issues that come up, make it vital to have an Aboriginal legal service that provides a truly culturally relevant service.
Will you be able to assist some of the people this morning? Okay, all right, we'll see how we go. If we've got languages that we can't, we'll start with what we can start with.
And we meet the translators for an insight into the lives of clients who are trying to balance their cultural obligations with legal obligations.
Professional, trained interpreters are the only way of alleviating the huge communication barrier that exists in the Northern Territory.
Bush courts have been a feature of the Northern Territory's justice system for decades. Beyond the main centres, court convenes regularly at more than 30 remote communities. At Aliangoola on Grid Island in the Gulf of Carpentaria and at Goombullunya in Western Arnhem Land, court comes to town once a month. In Darwin and in the bush for an intimate insight into the Northern Territory's justice system.
I want people to understand that they're entitled to have access to justice and to understand what goes on in court.
So make sure you come to court.
Over 3 weeks, we recorded hundreds of cases.
I think it's really, really important that we stay in touch with what's happening elsewhere. It's important to remain shocked.
Ms Hancock, the criminal history is literally littered with offences that relate to alcohol misuse. Is the defendant going to do anything serious about his alcohol misuse?
We captured a system overwhelmed by alcohol-related crime